Can everybody hear me?
Yes, sir.
Yes.
Yes, sir.
All right, good deal. Looks like I got everything working. On. Is that better? All right. I'll move it closer. Have we got everybody?
Yes, what's the problem? Okay.
Have we got everybody necessary?
Judge,
Yeah, I hear you.
relative to Megan, she's having technical difficulties. She wants to log out and log back in to see if that won't
All right.
do it.
Okay, that's fine.
Okay. You hear that? It's okay.
And just so everybody knows, court reporter's in here with me.
Okay, all right. Can everyone hear and see me now? I apologize for that.
No worries. So is that everybody that we need?
Holly, are we waiting on Sue or?
No, Your Honor. She has federal court depositions this morning.
Good. All right, is everybody ready? Okay.
Yes.
I apologize if I could have just another moment. I'm having a real difficult time hearing everyone. Let me see if I can fix it. All right, can everyone still hear me?
Yes.
Yes.
Okay, I fixed it. Thank you all for your patience. I appreciate that. I'm not
Sure.
sure what my system there.
Now, it's been a while since we've been doing it or have done Zoom, so I get it. All right. Court's going to call cause number CCL1-PR2020 0688, styled in the estate of Margaret Teresa Schmidt et al. Here today on motion for continuance filed by the plaintiff counsel in the matter. Will the parties please make their announcements?
This is Holly Crampton, attorney for Richter.
Megan Lovelady, attorney for Richter and other plaintiffs.
Sabrina Galvin for cross-defendant Derek Allman.
Anthony Bates for Margaret Moffett.
Lance Clack for Bankers Life and the affiliated entities.
Matthew Rent for Wesley Cusby.
Steve Huffer, also for Bankers Life and Affiliates.
All right, sounds like we've got everybody. Court will take judicial notice of the contents of the file and inform the parties. I have read the motion. I have read the responses. Ms. Crampton, anything you'd like to add to your motion?
Well, I'm going to defer to Ms. Lovelady, Your Honor.
Great. Ms. Lovelady?
If I may, Your Honor, did you have the opportunity to read the plaintiff's reply to Defendant Allman's response?
Filed yesterday?
Yes.
Yes, I did.
Okay. Okay, great. I don't have anything to add to the reply. I do have an argument that I would like to make before the court relating to this matter.
That'll be fine. Go ahead, then I'll give everybody a chance to respond.
Okay. As I think everybody now knows, I'm fairly new counsel in this matter, and it has taken me a little while to get acquainted with the file in the case, but I have now sufficiently done that. And in doing that, it has become obvious to me that this case requires discovery to be reopened, and in support of that position, we would show that the discovery period in this case ended before several parties were added, and in addition to that, within mere days of when additional claims were made in this case. Part of the reason that the additional claims and parties were added is because of a potential concealment issue that we have with one of the defendants that relates to a packet that was handed out just after Miss Schmidt's death in this case, that indicated to the plaintiffs that they could expect to receive the funds from these annuities somewhat shortly. And it was only after the original petition had been filed that the plaintiffs were made aware of the true details of these annuities. And so the original petition in this case that the discovery deadline is being based upon is from a time frame when the plaintiffs didn't have nearly all the information in this case. And in my reply, I point out case law. The name of the case is In Re King's Homeowners Association. And in that case, it's a similar situation, except that none of the parties ever came to the court and asked for a new discovery order. It's similar in that case, there was only one party added after the discovery period had ended. And in this case, there are multiple parties who were added. But essentially what the parties did in that case is continued conducting discovery as though the discovery period hadn't ended. And then at a certain point, one of the parties moved to exclude an expert witness because they had been designated after the timeline had passed. And what the court said was that they weren't going to exclude that witness. And in addition to that, what would have been much better practice was if the parties had either come to an agreement and submitted a new agreed scheduling order, or if they had come to the court and requested a scheduling order. And so in order to have the better practice that the court suggested, that's what the plaintiffs are doing today, is coming to the court requesting a continuance on this trial that would allow for a new scheduling order. In addition to that, the plaintiffs believe that Rule 190.5 in the Texas Rules of Civil Procedure require, in this case, that additional discovery be allowed. And the reason for that is because this case falls into actually both prongs of that requirement. That means that the court must allow for more discovery. In the first prong of Rule 190.5, this case fits into that rule because the first amended petition was filed 6 days after the discovery deadline, and that first amended petition added multiple new parties. And so that's an amended filing that falls within, it's related to a new amended or supplemental pleading. And the second prong of that is if they were made after the deadline or so close to it, it fits within that prong. And then the and of that is that the adverse party would be unfairly prejudiced without such additional discovery. And in this case, we have not only the first supplemental petition, but we also have defendant Moffitt's counterclaim that was filed 5 days before the discovery deadline ended. There was no way for either the plaintiffs or the defendants to have time to conduct discovery on these new and very material issues that arose after the discovery period. For Section B of Rule 190.5, this case fits into that prong as well, because what that prong requires is that the additional discovery be allowed in the event that there are material changes that happen after the discovery deadline and the trial is scheduled more than 3 months out from the discovery deadline. And this case fits into that prong as well. And then finally, in addition to those matters, there is good cause in this case to amend the discovery control plan and allow for additional discovery, because there are a few things that the plaintiffs have had to contend with in this case that justify that good cause requirement. And one of them is that one of the plaintiffs passed away, and there was a significant amount of probate procedural matters in that probate issue that arose that needed to be dealt with. And those things were dealt with from the period of the very end of 2022 until only just a few months ago. As the court, I'm certain, knows, Robert Weller was only named as the administrator of that estate, therefore the representative of the estate for the purposes of this case, in June. The reason that is significant and had to be done by the plaintiff's counsel in this case is because without it, we would have risked having in the successful outcome, in the event of a successful outcome in this case, the plaintiffs would have risked having a judgment that wasn't collectible. In addition to that, they wouldn't have been able to mediate in good faith because they wouldn't have had a party who had the authority to mediate in this matter. Additionally, there were questions about whether the children of Miss Weller needed to be brought in as required parties. And while that's all been resolved, it took time and resources from plaintiff's counsel to be able to address those issues in a time frame that was very, very near when this trial has been scheduled. In addition to those matters, we also have the issue that we don't have an answer on file or at all from two of the defendants in this case. Additionally, there has been one or two initial disclosures done, and those particular issues are things that are simply required for the plaintiffs to be able to conduct meaningful discovery and appropriately advocate for their clients in this case. Those are just basic requirements that the plaintiffs need to be able to represent their clients' needs in this matter adequately. And for those reasons, we ask the court to grant our motion for a trial continuance. And issue a discovery control plan that corresponds with the new trial date.
Okay, thank you. Who would like to be the first to respond? Doesn't matter to me. Y'all get after it.
Oh, I can respond.
Yeah.
Your Honor, I'm a counsel for cross-defendant Allman. We don't believe that the plaintiffs have shown good cause for the court to reopen discovery at this point. It's our position that they have not, conducted meaningful discovery throughout the 3 years that this case has been pending. They served interrogatories in the last month, but prior to that, they never served any interrogatories, any requests for production, not during the applicable level 2 discovery deadlines or afterwards, but yet they are serving them now. They've never requested to conduct depositions. They've never requested to enter into a discovery 3 plan until 3 years after the fact. So it's our position that they have not shown good cause to justify reopening discovery at this point. And in terms of trial, cross-defendant Allman is ready to go to trial on the set trial date. So we do request that the continuance be denied and that the court doesn't enter a level 3 discovery control plan at this point in the case.
Thank you. Anybody else wish to be heard, or would they concur with the arguments that have already been filed and that of Ms. Galvin?
Now, Lance Clack for Bankers Life, Your Honor. We would concur with the arguments made by Ms. Galvan. Certainly, there was time after the new defendants were joined where if the plaintiffs wanted to try and do discovery, they could have done that. And the court will recall we had a hearing where that prospect was discussed, and then nothing happened for 18 months. So we would concur with the arguments made by Ms. Galvan.
Thank you.
SD confers with the other defendants in this matter and has nothing additional. Thank you.
Ms. Moffett also opposes the continuance, Judge.
Anybody else? Ms. Lovely, do you have any response to that meaningful discovery was not done at all by the plaintiffs until recent?
I do, Your Honor. There has been some exchange of documents done over the time frame that the defendants are referring to. However, it hasn't been done in an official capacity, and it couldn't have been done in an official capacity because the discovery deadline had already passed. And whether or not the request for this new discovery control plan should have or could have been requested earlier in the game, that is an argument that according to Rule 190.5 doesn't matter. We have issues in play in this case that require the court to allow for additional discovery. In addition to that, I would say something that was also brought up in the case of In re Kings that I have mentioned a few times, and that is that in that case, the court pointed out that while the plaintiffs had not requested a new discovery control order, neither had the defendants. And because of that, the court was inclined to allow parties who had been disadvantaged by that to not be so prejudiced that that it would be fatal to their case. I don't think that that's exactly how the court ordered that. In fact, I know it's not, but that was the gist of the case. And that is exactly the situation that we are in here without additional discovery being allowed. The prejudice that will be put upon the plaintiffs in this case is extreme. And it's not necessary for the plaintiffs to suffer that burden because there is plenty of case law and rules within the rules of Texas, the Texas Rules of Civil Procedure that allow for the plaintiffs to obtain additional discovery and a continuance in this case.
Let me ask you this, Ms. Lovelady, what remains to be done to prepare for trial? I mean, I know you said you would like an answer and some initial disclosures from certain parties, which could be accomplished rather easily since we're looking at a November trial date. But what else needs to be done? I mean, where are we at?
Well, in addition to discovery that needs to be done to simply obtain the documents that parties already have, but that weren't gotten through official discovery processes, so that we don't have evidence that has been authenticated, such that we would be burdening the jury with having to authenticate each and every piece of evidence that came into court. In addition to those issues that need to be resolved through discovery, there's not really any way for the plaintiffs to know at this point what additional discovery needs to be done without having gotten basic responses from some of the defendants and disclosures from other defendants. Those disclosures and responses could open up a whole new set of inquiry that plaintiffs' counsel needs to make to be able to thoroughly and fairly advocate for their clients, so that the court can adjudicate this case accordingly.
Well, I understand what you're saying. What I'm getting at, I'm being a little more specific. Anytime you do discovery, it could lead to more discovery, and then it could lead to more discovery, and we could do this ad nauseum. But at some point, the defendants also have a right to have this matter resolved. I mean, it has been 3 years, and I know you're new to the game, but Ms. Crampton is not, and it's been 3 years. And I know a lot of the discovery and paperwork was done by agreement, which I do appreciate. But at some point, this case needs to be tried. And
Yes, sir.
keep going and going and going. So I'm asking specifically, what needs to be done at this point?
At this point, disclosures need to be made by multiple parties. Depositions of multiple parties need to be done. And then there's some discovery that has been sent out but hasn't been responded to. I think that for the most part, the deadlines haven't passed on those responses. But considering that we're outside of the discovery period, I don't know whether or not to expect responses to the discovery that has been sent out. So it's unknown to me what discovery still needs to be sent out, because I don't have responses to what has been sent out already.
Okay, the next thing, my question after reading everything and listening today is, how long do you expect this to take? If you're going to get on your horse and we're going to get this thing ready for trial, how long will we need?
I believe when Attorney Clack and I had spoke about this before, what would work for at least the two of our offices would be in the time frame of, and Attorney Clack, correct me if I'm wrong about this, I believe it was at some point May through July was what worked for our two offices. And that relates, that's sort of twofold, because it relates to the time frame that we'll need to conduct appropriate discovery in this case, but really more than that. And the reason why it's a little further out than I think is necessary is because of the coordination between all of the different counsel in this case and all of the multiple parties involved. And Lance, pardon me, Attorney Clack, am I correct?
Yeah, I would say this. I mean, it's basically like a new case. I mean, we've gotten document requests and interrogatories, I think some RFAs in the last couple of weeks, but no depots have been taken and no experts designated. So, I mean, we're back to 9 months from today if we're going to do that.
Let me ask a question of the plaintiffs, and not meant to slight anybody or anything like that. Ms. Crampton, please don't take it that way. It appears to me that now that Ms. Lovelady is in, Ms. Crampton, is Ms. Lovelady kind of driving this now a little bit more? Am I?
Yes, Your Honor, very much so. I'm very comfortable with her taking lead counsel, and and quite frankly, I miscalculated the expert designation. I thought we had time to go to mediation, have mediation done, designate Ms. Lovelady's office. Her paralegal was very quick to say, oh, no, it's 120 days, it's not 90 days. And so that's, and we're facing some very expensive experts relative to the plaintiff's part of this case.
Understood. Well, I did not see it in the file, and maybe I've missed something. Was mediation actually accomplished in July, or was that put off because of?
Now it's my understanding that there's some discussion about potentially revisiting mediation. It was a rather expensive one. The plaintiffs do not object at all to that. I don't know whether that would come to be, but I know that's something that's been under discussion.
That's good. All right. Anything further?
No, Your Honor.
Anybody else?
No, Your Honor.
Okay. All right. I'm going to take the matter under advisement, and I'll have a ruling for y'all by the end of the week. I just want to go back and look at a couple of things. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank y'all. I do appreciate it.